vocês quando estivermos ao vivo.
Ok.
Perfeito.
Doutores, estamos ao vivo. Também vou colocar ali no link comentado essa questão do probleminha que a gente teve aqui com o Captions, tá? Daí o pessoal já vai poder acompanhar aí.
Ok, muito obrigada. Então, bom dia, boa tarde, gente. É uma honra estarmos aqui reunidos para tratar desse tema que está tão em voga, né, e tão premente, a respeito da inteligência artificial aplicada para situações voltadas à advocacia. Então, estamos aqui com um projeto construído em conjunto entre a Comissão de Gestão e Empreendedorismo, Comissão de Direito Digital e Proteção de Dados e Comissão de Sociedades de Advocacia, para tratar com especialistas. Então, teremos hoje, na sequência, iniciando pela doutora Karen Taruffi, que está falando direto de Paris. Teremos também, na sequência, o doutor Juliano Maranhão, de São Paulo, da USP. E, na sequência, teremos o Damian Hill, que falará direto de Chicago. Então, inicialmente, a ideia seria que a gente pudesse usar a ferramenta da inteligência artificial para fazer uma tradução simultânea das falas, mas tivemos aqui alguma inconsistência, né, mostrando que a inteligência artificial ainda está em construção, e, posteriormente, a gente vai atualizar as traduções e, né, as legendas para disponibilizar amplamente para o público, para quem não conseguir acompanhar nessas outras línguas estrangeiras. Então, iniciando, vou passar a palavra para o André, para que ele inicie os nossos trabalhos.
Obrigado a presença de todos e todas, é muito, muito gratificante poder participar desses projetos, intercomissões, e esse é um tema muito relevante. Eu vou pedir licença para mudar para inglês, em atenção à nossa convidada, que falará também em inglês, então eu vou iniciar apresentando a doutora Karen Taruffi em inglês. Então, vamos lá. Karen Taruffi is an expert advisor on AI, especially in legal and ethical issues for various international organizations, such as the Inter-American Development Bank, for the European Union too. She's an author of various scientific and non-scientific articles on artificial intelligence, bias discriminations, AI reliability, and others. And she has published 2 books. She's an international speaker. As you can see, she's speaking for us too here in Brazil on AI-related topics, risks, biases, discrimination, the upcoming European regulation on AI, and other topics. And she is a leading practitioner on AI issues in Europe. Karen also is an adjunct professor of higher education in Paris. She's responsible for setting up the first trustworthy AI lab in Spain. Furthermore, she provides high-level online and on-site training on artificial intelligence, ethical, legal implications of AI, and provide consultancy on AI, ethical and legal issues for private and public organizations all over the world. So, Karen, welcome, and the floor is ours.
Thank you very much, Andre. Would you share, please? Yes, you have 2 slides there. So, request you please to share the first slide to provide an
Okay.
Okay. Let me know when that is ready, please.
Let's start. Just a moment. And
in the meantime, Andrea is preparing the presentation to share. I would like to I am very happy that you invite me for this conference. I think that Brazil and in general Latin America, which I understand that regulation is going slow there, I think that it should be very welcome. Can be very welcome to the lawyers understand whether they'll understand how it works, this technology. I think that this is not my presentation.
Yeah, no, it's not your presentation.
Yeah. And I think that for lawyers and law firms and other organizations which are using this technology, Gen AI, which one of the examples are ChatGPT and BERT and so on, I think that they should know what are the benefits, but also what are the limitations and risks, how they should use this technology to really empower themselves as a professional, but also as a company or as an organization. And you don't take measure if you don't know what are the risks and the limitations of this technology. So just a sec, I would like to put a small disk here. Okay, so I think there it is. Now I'm here. So I was mentioning that it's important. I have just 40 minutes here now. So will be 30 minutes, 10 minutes for each. I will try to match the time that you suggest me. So we will talk about main issues and limitation of the use of generative AI. I will say in the future maybe Gen AI, which will be easier and very, very easy to manage. And after we will talk about AI hallucination versus risk of use Gen AI. After we will talk about confidentiality of information, which is a very hot topic currently, and regulation versus ethical issues. Okay, and well, before to talk about the three topics, I think that maybe not all the lawyers, the professionals that are here are aware of what is the concept. Before to talk about what are the limitations, what are the benefits, we should understand what is Gen AI, right? So Gen AI is, we can say that refers to the category of artificial intelligence technology and models that have the capability to generate content such as text, image, music, and other forms of media. Gen AI systems are designed. This is very important word that you need to remember all the session. Gen AI systems are designed to produce content. After we will talk about if it's created content, they build content, or so on. Okay, so but we can keep in mind that Gen AI systems are designed to produce content. Okay, that is of course coherent and contextually relevant based on the patterns and information they have learned from large data sets during their training. So of course, in order to produce content, they should be trained with a lot of data, which we call data sets. Okay. One key characteristic of Gen AI is the ability to build, again, I don't say create, after we will discuss about this, but to build content autonomously, often in a creative, human-like manner. Like that means like a human, right? Gen AI models are widely used for various applications, including text generation, which is very useful for the legal field, you know that. Image generation, music composition, video generation, language translation, and content summarization, which also, again, is very useful because as a legal consultant, lawyers, and so on, we need to read and summarize a lot of information and provide reports and so on, okay? So now we're going to start talking about main issues and limitation. I will talk about the little general information, but very short, and after I will go straight to the point, okay? So the main issues and limitations of the use of Gen AI, we can talk about the risks and limitations, right? So I really would like to be there in order to really have a more interactive conversation. But well, I am far away from you, but I hope that one day we can discuss this personally there. And we need to understand to manage well this technology. We need to know the capabilities, the limitation, risk, in order that the outcome of this technology can be positive for us as a professional, but also if you are using it in your company, if you are the director of the company or the CEO of a company, talking about law firm, consultants, firm in that regard. So here is important. It's not regarding talk properly about this new technology. I am not against this technology, but I would like to share with everyone what are the limitations, because if you just hear what are the positive effect of one technology or one product, you are biased in that regard. So as a professional, you need to be serious. And in that regard, that means that you need to understand limitation, risk, and the benefits to the outcome can be very useful for you. So talking about risk, and limitation. When we talk about risk, we are talking about biases and unfairness. That means that GenAI models can reproduce and amplify existing biases and unfairness in the data set on which they are training, which can lead to unethical result. After we will see like a context when we are talking about it, right? There is the potential for highly sophisticated generative models to be used to create fake image, video, audio, which can be used to mislead or confuse people. But I will go straight to the point after. And there is a case that fake news can be used here in Spain. This is just this month, and it was used to, how I can say this, from students in the school, and they have created a fake photo from colleagues who are usually girls, and they appear naked. So we can talk about different things in that regard, and I will go straight to the point. But before going to the for the legal sector, the risk limitations, I will just comment this. What happened in the legal sector is that when some technology is coming to the market, usually what I perceive is that financial sector usually is the one who take these new technologies in the first place. And so maybe we as field from the legal industry or the legal sector, we can learn from them also. If one sector is using this technology, or they are more open to use this technology before us in the legal sector, so maybe we can learn what they have done well and what they have done wrong. So some companies' reaction, I would like to mention, after I go after for the legal field risk limitation. So in February this year, JP Morgan Chase implemented restriction to employees' usage of ChatGPT. When we are talking about GenAI, everyone knows that we are talking about example, ChatGPT, BERT, and so on. So the decision of restrict employees' access to the chatbot, they create like a kind of guidance. So the employees have restriction to use ChatGPT. Why? They say that it was made without any specific incident prompted, but they were how can I say this? They said that they were concerned about the potential that can produce inaccurate or misleading information. And not just JP Morgan have done that. It was done also for other financial firms like Bank of America, Citigroup, Deutsche Bank, Goldman Sachs, and so on. So now I would like to talk specific for the legal field risk limitation. GenAI has shown, as you hear before, even like great promises in various applications. We know that because we have here a lot about that. It's like someone is telling us something, but also we need to understand that when something is too good, we need to have kind of awareness that we need to understand very well who is talking about this technology and why he's talking about this technology, to know if that person is very objective of that, or is that person have enough information to talk about that. We need to really, we are in the era when we need to question ourselves about what we are receiving as an information, if it's an objective information or not. We need to be very, we need to really put a lot of attention on that, okay? So here, there are some main concerns regarding risk and limitation of Gen AI, for example, quality and accuracy. While Gen AI can produce coherent text, it is not always accurate. What means that, or trustable or reliable? For example, legal documents and advice require high degree of precision, okay? And Gen AI may contain errors and inaccuracies that could have serious consequences for clients. That means we can see one example: a Gen AI system might produce a contract that contains errors and ambiguity, leading to potential legal dispute down the line. For instance, it could misinterpret a term in a contract, so resulting in unintended consequences that can be negative for the client and also the reputation, again, for the law firm and also for the professional. Lack of legal expertise. AI lack the deep understanding of legal concepts and case law that human lawyers possess. It cannot provide a contextual understanding of judgment that lawyers use to make decisions. Maybe we have here that Gen AI process information like human, but that is not true. It's a technology that tries to mimic how the brain works, but it doesn't do it the same way. So there is a recent article in that regard. So this technology don't have the context to really address, to really have an answer that the expertise that a lawyer can have, okay? It might generate advice that fails to consider relevant legal doctrines or recent court decisions. So if a lawyer or a legal consultant or a practitioner go to Gen AI to find the results of what should be the advice, it might like maybe that Gen AI that I would say ChatGPT, maybe it doesn't have the recent regulation, maybe it doesn't have the recent doctrines, or maybe it doesn't have the recent court decisions. So it's not very specific in the expertise. Regarding ethical and legal concerns, using AI to draft legal documents, of course, you gain a lot of time when you are doing that, but also providing advice. You have a report, you can provide advice, but raise ethical and legal questions. For example, lawyers have a duty to provide competent representation, and relying 100% in AI might not meet the ethical obligation, but also relying 100% on AI-generated advice without a lawyer to review might violate ethical obligation. For instance, a lawyer who used AI-generated content for a client without understanding or verify it would face disciplinary action. We will see little by little in different countries, I think. Again, it's not just that, but also reputational damage for the firm, but also for the lawyer. So it's important to consider the ethical and legal concern, even the regulation is not in place right now. Regarding, I will say also, I will mention this here also, there is a case in the US when they have used Gen AI, okay, ChatGPT, okay, to produce a report, a legal word for a client, and after it had hallucination that we will talk later here. I really consider that in the best case, if a law firm of a lawyer or a legal consultant will use this technology or is considering use this technology, that person need to know really the subject, because it can have hallucination and can really provide you a very wrong or false outcome. So it's important to say that. Regarding another point important is regarding data privacy and security. For me, there are many alarms here. For example, the first question is, where go the data? The data will be in my computer, the data will be in a cloud. But not just that, I need to ask myself with who I am sharing the information. So many, I mean, even as I don't think that lawyers in general, this is my guess, okay? I don't think that lawyers and in general people are reading that small information regarding the confidentiality of the use of this technology or the data privacy or the data protection. I don't think that there are. So when we are using this technology, we need to see exactly where the data goes, and plus where with who they are sharing. The question, in fact, is they are sharing my data or what? So legal documents often in the legal sector contain sensitive and confidential information. Using AI services that process such a data raise privacy and security concerns, especially if the AI system is cloud-based, so I mean it's in the cloud. So what I want to say here is that even if the company want to do, even if the company say, look, I am doing in the cloud, I am putting all the information in the cloud, and I don't share your data and so on. Right now, we are living in a century where nobody can assure that not going to be a cyber attack or cybersecurity threat. Regarding this risk, it's a risk that can decrease, but nobody can assure you that it's going to be 100% free. That's going to attack the cloud and going to take not going to take your information. So this is important to mention. Also regarding bias and fairness, AI models can inherit biases presenting the training data. So when we are talking about, for example, for different cases in the legal sector, as a woman, I think that we were living in a era when maybe a lot of bias in the regard maybe against women. There are in the legal sector, and maybe if we are not aware that because they are training this data that was biased for a long time, now they are changing. Maybe we are using this data that can be negative in the end. For example, if a generative AI model is trained bias in legal text, it will generate documents or advise that perpetuate discriminatory practices or favor one group over another. So it's important to know also this. Customization and context. Again, AI, Gen AI, ChatGPT. When I talk about Gen AI, I will insist I am talking about ChatGPT, BERT, and so on. The model, the structure is Gen AI, okay? When we are talking about ChatGPT, we are talking about a brand, but many technologies, similar technologies are coming up, okay? So it's customization and context. You request information there in the ChatGPT, for example. It can provide the report, can provide the content, but can provide very customized content, like exactly for your client. It's usually very general, and it doesn't provide you a context. As a lawyer, as a consultant, you need to know the context, and usually you know the context because the client has provided this context. And you really can do a very precise suggestion, or can really provide the service that the client needs. In this case, AI might struggle to provide a level of customization and the context that lawyers can. So you need to know also that. lack of creativity and strategy. So part of this conversation also, I have requests in ChatGPT to understand if they are aware of this. And what they said is that legal work often involves creative problem solving and strategic thinking, which AI currently cannot perform. So they said that currently, I think that they are exploring if they can improve this, but right now it's not a reality. Okay, they cannot perform this strategic thinking, problem solving, and so on. Lawyers provide insight, negotiation skill, and courtroom presence that AI cannot replicate. Still, lawyers can do their work, right? Example of this is a complex litigation. Lawyers use creative and strategy to develop arguments. On the other hand, AI lacks the ability to think creatively or adapt to evolving circumstances during the trial. So that is also important to know. The other point is regulatory compliance. The use of AI in the legal practice might be subject to regulatory scrutiny and compliance requirements. Lawyers need to ensure that their AI tools meet this legal and ethical standard. So maybe some of you can say, look, Karen, right now in my country, there is no regulation, no regulatory compliance here that I need to be aware. But still, if you care about your reputation as a professional, still if you care about the reputation of your law firm, of your organization, company, and so on, I think that even the regulatory compliance is not in place, you should consider ethical guidance in order to really take the outcome, to really take a very positive outcome. Knowing the limitation and the risk can help you to address, tackle the limitation and the risk of this technology. Okay. Again, other point here is the limited precedent for liability. There is a limited legal precedent regarding liability of GenAI legal content. Lawyers might face challenges in the determining responsibility if AI generated work leads to adverse outcome. What happened? Who is responsible? If something is going wrong for example, if an AI generated contract result in a financial loss for a client, which can be a person or a company. So it depends on that and the topic, the amount of money that they're going to lose. So it might be unclear who is legally responsible right now. The judge should determine that. Should be responsible the lawyer who used the AI tool, or the AI provider itself, or the law firm which implement this technology or which allow to use this technology. So we need to think very well in that regard. In short, well, GenAI has the potential to assist lawyers in various tasks because always they are talking in newspaper, all the benefit that has GenAI, ChatGPT, and so on, is not a replacement for expertise, judgment, and ethical consideration that human lawyers bring to the table. In the best case, again, lawyers must carefully consider the limitations and the risks associated with AI in the practice and use this as a tool to complement rather than replace their legal skills and expertise. Additionally, they should stay updated of the legal and ethical guidance related to AI in the legal profession as regulation evolves. Also, again, what happened here in Brazil or other countries that the regulation is not in place. Still, if you are responsible and you don't want to harm your brand as a law firm or as a professional, you should consider to have this kind of consider this technology as a tool, but also the person, the outcome need to be addressed, need to be edited, I would say, edited by a senior or someone who really know the subject. For example, if we are talking about liability of consumer in the for telling something in the electric sector, something like that, something, it can be everything, okay? And if you invite a junior lawyer to do that, even if he doesn't have or she doesn't have the knowledge, the full knowledge, right? The outcome not gonna be, and you present this to the client or to the court or wherever, you can be 100% sure that someone going to find something wrong there. So a senior lawyer or someone who really knows the subject need to edit this content. Otherwise, you are putting in risk your reputation, again, as a professional or as a law firm. Now, I would like to talk about AI hallucination, and I think that I will go very fast because I see that time is very limited, and I have a bit time. Yes, I understand that AI hallucination versus risk of use Gen AI. Okay. I understand by hallucination that this technology makes convincing claims that have no basis in reality. Okay, recent discussion have concluded that this model do not hallucinate. Karen, why you call hallucination? I have sorry, I don't know if everyone is listen to me or not.
Yeah, we are.
Yes. Yeah, because I was reading here other comments. So okay, thank you.
Yeah, we are listening.
Okay, thank you. So okay, we don't need to call hallucination to this because very simple. Hallucination is a capacity from a human, okay? And this is a technology, okay? So there is, even in Harvard, they discuss this regarding AI hallucination, Gen AI hallucination, and so on. We cannot talk about hallucination, okay? So, because what? Again, because it's a human capacity, not a tech capacity, okay? The way that we talk about this is that AI, rather than hallucinate, we can say that build false statement, and usually they are very convincing, okay? I will mention also, Karin, why Gen AI hallucinate? Is because, again, do you remember that I asked you, please, to remember what is the nature of this technology? This technology was designed to produce content, to build content, and other people can say to create content. But for me, I don't want to use the word create because, again, for me, create means it's a human capacity, not a tech capacity. For now, my understanding is in that way. I am conservative in that regard. So, designed to produce content. So, I will go again to hallucination, and because that, what happened with the hallucination? When the Gen AI, when you know that it's trained with a data set, with a lot of data, amount of data. So when the Gen AI, when the generative AI, when the ChatGPT hallucinate, okay, it's because they don't have, this technology don't have enough data to provide you the outcome. Okay, so it's building something just in order to satisfy your answer. So you understand now? And generative AI hallucination overview. For example, we will talk about 2 points here: imagination over precision, AI imagination. Again, you know? We cannot talk about imagination, but we can, because it's a human capacity, right? Rather than a machine capacity of tech capacity. AI might prioritize imagination and creativity, again, over precision generated content that might sound impressive, but not legally sound or accurate. Okay? The second point is lack of factual bias. AI generated content might lack of factual or legal basis, potentially leading misinformation, misinterpretation, or misinterpretation. So again, this is the risk, and also this is the risk. And also you can, if you want the limitation, risk of the use for lawyer. I mean, put attention here. If you were not putting attention now, I suggest you to put attention, because if you are using, or you want to use more, you are thinking to use this technology, ChatGPT, BERT, and other Gen AI, you might have this kind of risk as a lawyer: misleading content, ethical concern, legal liability, and client trust. So we talk about misleading content. Lawyers who use Gen AI content that appears convincing, but actually is incorrect or legally flawed, might unintentionally mislead client to the card. So it can provide outcome with error. So again, because that if the outcome of this technology should be analyzed for a person who really have the expertise in that subject, in that content, in that topic. Okay, again, ethical concern relying solely on AI-generated content in the legal work without verification again, or professional judgment could raise ethical concern about competence. Okay, competence, diligence, and the duty to provide competent representation. Of course, if you provide me, as for example, I am the client, you are my lawyer, or my law firm who represent me, or I am a company and I ask you a report and I give you a representation, and in the end you provide me a wrong presentation, a wrong report, a wrong information to the court, to me as in the report, and I realize that I will think that you don't have the level to represent me, and that you are not competent, and when you have a negative comment as a professional or as a law firm, let me tell you that it's very difficult to change that course, the perception of your work. Legal liability, if, for example, if an AI-generated hallucination leads to adverse legal outcomes for the client, again, lawyers might face legal liability for negligence or malpractice. Maybe right now you are not talking about that, but it will come. Okay, client trust. Again, if you lose the trust of the client, you are done. I think as a lawyer, because good comments about a lawyer, good comments about a law firm is very slow, right? Go very slow in the communication. But the bad experience of a client is very negative for a professional as a lawyer or for a law firm or a company. Okay, so I considered also I am going to in November, I think. I already presented an article, and it will be published in November, middle of November, I think. I wrote an article with my colleague Blaser about this topic, Gen AI in the financial sector and in the legal sector, and I will share this in LinkedIn. So I hope that you are following me there, and you will see there is a lot of interesting resource there. For example, a consideration that I share with my colleague Blaser, that I will share the publication in the middle of November, which is an expert in Shine, like explainable AI. So I share his comment when we don't know, if we don't know adequate fix for fight hallucination, new tools based on this technology might bring more problems than solutions. That is the way that I think. I hope that you can you can have this awareness about the limitation and risk, but also if other lawyers don't do that, the problems will be higher than the benefit of this. Regarding confidentiality of information, which is a very hot topic right now, the state of art, from my point of view, that can be, is what I think, okay? And the companies which build this technology, Gen AI, I think, and I hope it's not true, just I am guessing, maybe have done how they get all the information from that. Made me guess that they were scrapping from internet information, because right now we hear that authors from books, different books, even the Harry Potter book, I think that also, and actors in general, they are they claim that they were kind of sorry, I am mistaking this, confidential information. Yeah, okay. I'm going to talk after I think about the intellectual property. I was confusing this, but this is also a topic, confidentiality. Gen AI poses potential risk to the confidentiality of information, particularly when it's sensitive, when the data is sensitive. Okay, and in the legal sector, we have a lot of sensitive data. Companies, there are law firms or lawyers or other legal consultancy firm that even, for example, they have as a client pharmaceutical companies, and we can still talk about banks and so on, right? So even for people as a human being, they have maybe confidential information that I provided to the law firm or to the lawyer, and in the end, they put all in ChatGPT in order to get the best information or to summarize, and they are providing this information to be sold, to be shared, or to be in the cloud. Maybe can be breach there. Examples, for example, text generation and data privacy. Gen AI models can be trained on vast data sets in my contain sensitive data or confidential information. If this is not handled properly, okay, if the company which create this technology don't have properly, and also you as a user, there is a risk that these models will inadvertently generate text that reveals confidential details. For example, a customer support chatbot could accidentally disclose sensitive customer information in a response. Regarding the legal sector, I cannot provide right now information, but maybe I can provide information if I remember well, is regarding Samsung. I think that their employees use Gen AI to do kind of work regarding a technical thing, and they were sharing this private information or confidential information from this company. The second point is AI language models in document redaction. AI language models are used for document redaction, such as removing confidential information from legal documents or medical records. However, if the AI model fails to properly redact sensitive data, it could lead to data breach. For instance, a poorly redacted legal document could inadvertently reveal personal information. Yeah. And regarding this, we can talk about the GDPR in Europe and the California consumer privacy that try to tackle this kind of issues right now, but still I find that it's not enough. And because that in Europe, I hope at the end of the year, they are publishing the AI Act, which of course will approach these issues in a proper way, I hope, but I think that it's very complicated. The other point regarding trends and recent news regarding this good AI models, auditing, AI ethics and bias, and secure development. Also, there are legal implications. I will go in there because the time is very limited. Legal implication, the potential for data breaches or privacy violation by AI system has legal implication. Organizations might be held responsible for data breaches caused by AI-generated content, leading to lawsuits, and regulatory fines. But now it's not your case, but still, I think that is thing to be considered. Regarding regulation and ethical issues, for me, it's very clear that here, when we are talking about regulation, we can talk about hard law, okay, that still you don't have, and even in Europe, we don't have. Just we have GDPR, as we mentioned before. But we can consider in that regard, okay, regulation versus ethical issues, regulation, hard law, and ethical issues, soft law. We can consider maybe in that way in order to understand very well the regulation of Gen AI and the ethical issues surrounding its use are closely interrelated, but represent different aspects of its governance. In the next comment, we will explore the relation between the regulation of Gen AI and the ethical issues. For now, what we can say right now is like in Europe, they have been talking about the guidance because I understand they understand that this ethical guidance is important because until the regulation will be published and be in place, it will take a bit of time. So I understand that there is a principle that we will discuss later. I don't know if you can put the next slide, Andre, please. And regarding regulation of Gen AI, the AI the state of the art, we can say that this is not related to the presentation that I will do, just in order to be in advance that presentation. But for example, regarding in general, and after I will go how Europe is handling this regarding regulation. And this, what you are seeing in the presentation, is the ethical guidance. Okay, so regarding regulation of generative AI, the state of the art, we can find a legal framework that the privacy, intellectual property, transparency, accountability. We can talk about also in general, okay, but in general, the countries are talking about. Regarding legal framework, we can talk about governments and regulatory bodies. Bodies are considering and in some cases implementing legal framework. It goes very slow to govern the development and the use of Gen AI. This regulation might encompass data privacy, intellectual property, transparency. I think that explainability also, usually they don't talk, but I think that is key element here, and accountability. Regarding the legal framework, what I perceive is that there is in Europe, we are talking about a lot about what will be the right regulations. We are discussing a lot, and what is interesting is that in Europe happen two interesting things. One, that the regulation is for all countries, right? It's for all countries, and they need to respect this. Okay, and after they will be handled individually by country, but they need to respect the regulation, right? This is what is happening. That is not going to happen, I guess, in Latin America, because you don't have this kind of similar to Europe, right? That is what is happening. It goes slow, I understand. And in the US, but I have the feeling that California is very proactive in that regard. And I think that it will be one of the first, maybe will be one of the first state that I think that going to support this. Also, and I'm sorry for my colleagues from UK, I have a strong feeling that in the UK they talk a lot, okay, regarding Gen AI, let's talk about guidance and so on, but I don't feel that this is my feeling again, I don't feel that they're going to regulate like Europe is doing. I think that they will regulate very, very late because they are pushing more produce and develop this technology rather than to protect. And sorry, you want to say something? Maybe I am very out of the time. Sorry.
Karen, we are going out of time. If you
sorry.
Finishing, okay. Sorry.
Yeah. You want that I finish, or you want to finish already this?
You can make some final conclusions on this.
Yeah, I will make
and then we can go to the next panelist so that we can maintain our proposed time. Thank you.
Yeah, I will mention that for now the regulation there is in place in the draft of the AI Act, okay, which is the regulation. Some requirement for Gen AI, okay, but the discussion that is currently is that it's very difficult to comply with this request. But we will see in the end how is the final draft in that regard. And what you see in this slide is that this is the ethical guidance that right now companies which are that AI developers, included Gen AI developers, need to consider in Europe in order to don't be banned or prohibited. But we need in that this is the guidance, okay, that the high-level expert of AI presented to the European Commission in 2019, and this is the guidance that I can say that companies that are really interested to maintain this technology in the long term, they are using this kind of guidance to do that. So sorry for extending me in that presentation. Yeah, thank you.
Thank you, Karen. It was very good to know your point of view about the team. We have one question for you. I think we can do this right now, okay? Kael, if you want to question Karen about
Yeah. Thank you, Rafaela. And well, Karen, first of all, congrats for your presentation and the great content that you bring to us. It's a path of no return, right? So I was thinking about what you said about the importance of knowing how to interact correctly with AI. And the stage where we are, especially here in the office, we are using APIs with ChatGPT to analyze documents, where we create a text layer in documents that aren't native digital and using OCR algorithms. And finally, using LLM's algorithm or ChatGPT to interact with this document, asking questions and extracting information, but always checking the information, as you said. So from this point of view, what you said about this next phase, where in my opinion, humans play two different, very different roles. Number one example, humans as creative minds and expert requesters, in other words, knowing how to ask to the AI. And number two, humans as auditors or curators of the result of what the AI produces. What's your opinion on this? In this case, I believe that the undergraduate courses will have to adapt in some way, right?
Okay. Karen, there are some words that I'm missing from your question. So if you can be more specific, that will help me a lot, because some words I'm missing some words. Sorry.
Okay, perfect. In my opinion, humans right now, they will play two different roles when they interact with AI. Number one, humans as creative minds and expert requesters. And in other words, knowing how to ask to the AI, because we need to know how to ask. Because
the prompt, they need to write, of course, they need to write a right prompt. Okay.
Yes, so this is the main role, in my opinion, that human need to develop, like to know how to ask, but with prompts, not with words. And of course, the second role will be humans like auditors, or we will need to check a lot, always.
Now I understand your question. Well, when I was, thank you for the question. When I was writing another article regarding GenAI, ChatGPT, and so on, I was thinking like, what would be my suggestion for lawyers who want really use this technology? Because come on, we need to read a lot of information and provide the best outcome there. So of course, for me, what's like, first of all, or for me, both are important, because what happened here is that we have senior lawyers or senior legal consultants that know very well the subject, okay? And I think, from my humble opinion, request them to learn this is time-consuming for them. From my humble opinion, request that to them. Like, they might be, some of them, they might be 60 years old, 50 years old, 65 years old, women and men, right? So for me, a very approachable way to tackle this, if the law firm of the profession law, if the law firm, I would say, we are talking about organization, maybe, should be like to find a right person, to write a right prompt. For my humble opinion, that would be more assertive, I think. And after this, I will do also maybe kind of brainstorming maybe before with the senior consultant to make understand, but it's kind of very difficult. Maybe new generation of junior lawyers, maybe they can be more and to write a right prompt, and after the outcome can be analyzed for the expert, which can be a senior lawyer, but also can be a lawyer with a lot of expertise in that area. That would be the right way to tackle the hallucination, the limitation, and the risk, I think. Thank you.
Perfect, Karen. Thank you.
Thank you, Karen. And now we revert, Rafaela, please.
Oh, I was saying that it was a pleasure having you here with us, and just thank you for your participation, and that we are looking forward to hear more about your articles in new opportunities. Very good.
And it will be great to see how this matter develops in Europe. And you are very close to the discussions in Europe. It will be very good. And a guidance to Brazil, in which country we are discussing now the proposal for the regulation of AI. And with this, Karin, and without forgetting to thank you for your generosity and for your kindness to participate in our event, in our webinar, I revert to Portuguese to introduce our next panelist, Professor Juliano Maranhão. Thank you, Karin. Thank you again. E o professor Juliano Maranhão, muito obrigado por ter aceitado o convite das comissões aqui da Ordem. Há 3 comissões reunidas promovendo esse evento. É uma grande honra, uma grande alegria recebê-lo aqui conosco para discutir essa questão. Farei uma breve introdução sua, tenho certeza que todos o conhecem também, sabem.
André,
por favor.
antes que você continue, eu vou pedir só para você parar de compartilhar a tela da Karen.
Deu certo?
Sim, obrigada.
Tá ótimo, obrigado pelo aviso, desculpem. Agradeço a sua participação, agradeço a sua gentileza e farei uma breve apresentação. Sei que muitos já o conhecem o seu trabalho, sua pesquisa e desenvolvimento nessa área, mas o professor Juliano Maranhão é doutor e livre-docente pela USP, onde é professor associado do Departamento de Filosofia e Teoria Geral do Direito, pesquisador da Fundação Humboldt e professor convidado da Goethe-Universität Frankfurt am Main. Foi professor visitante nas universidades de Miami, Leipzig e Maastricht, e é membro do Comitê Executivo Internacional para a Inteligência Artificial, da International Association for Artificial Intelligence and Law. E o professor Juliano vai nos brindar com uma apresentação a respeito de questões relacionadas e riscos relacionados ao uso da inteligência artificial, principalmente inteligência artificial generativa, pelos profissionais do direito, pelos advogados. E essa é a nossa preocupação aqui nas comissões da Ordem, de trazer essa discussão para todos os advogados que estão nos acompanhando agora. Obrigado, professor Juliano, muito obrigado pela sua presença.
Eu aqui agradeço pelo convite generoso de vocês, sempre um prazer tratar desse tema que está bastante na ordem do dia e já começa a afetar bastante, não só o dia a dia, mas a atividade dos advogados, né? Hoje, na faculdade, depois eu falo um pouco mais sobre isso, na Faculdade de Direito da USP, a gente começou a levantar elementos para desenhar uma política de governança sobre o uso do GPT na faculdade, e o BART, né, e as generativas de texto nas atividades da faculdade, porque imediatamente, com a divulgação da ferramenta e seu uso, começou a surgir uma desconfiança entre alunos e professores, ou principalmente os professores em relação aos alunos, sobre o uso da ferramenta de forma não transparente, e isso levou já alguns professores a cancelarem entregas de trabalhos, e de uma tal forma que a desconfiança acabou fazendo com que essa nova tecnologia trouxesse uma restrição nas atividades pedagógicas, né, uma limitação às atividades pedagógicas justamente pelo medo, pela incerteza, né? E então nós começamos a fazer esse trabalho justamente para resgatar, né, o que pode haver de benéfico no uso dessa tecnologia e o que efetivamente pode ser um risco e como lidar com isso dentro das relações dos professores com o aluno, isso vai estar dentro da política de governança, porque existe um potencial dessa ferramenta para trazer benefícios às atividades didáticas, né? Mas o primeiro aspecto é eliminar essa desconfiança, né? Ser transparente, ter regras claras sobre como usar, como o professor pode usar em aula, como os alunos podem usar nas atividades, já elimina boa parte da preocupação. Aliás, quando a gente fala em trustworthy AI, né, ou IA confiável, ou IA responsável, a transparência talvez seja o fator-chave, né? Não só porque ela é um valor em si, em qualquer ambiente democrático, mas principalmente porque ela também é instrumental em relação às outras preocupações que são trazidas pela inteligência artificial, né? Depois eu falo um pouquinho mais sobre esse projeto, se tiver tempo, no final da exposição. Eu tenho quanto tempo mesmo para falar?
Uns 25 minutos a partir de agora.
Ok.
Uns 20, 25 minutos, mais ou menos.
Tá bem.
Como nós acabamos atrasando, estamos tentando ajustar aqui as nossos limites aqui. Mas uns 20, 25 está ótimo.
Ok, sem problema, suficiente. Bom, então eu vou começar abordando quais são as preocupações trazidas pela inteligência artificial, que foram mapeadas em toda essa literatura que debate os aspectos éticos da inteligência artificial, do uso, né, dos sistemas de IA, que tem sido a motivação para a regulação da tecnologia. Vou falar de IA em geral e depois especificar de que maneira as IA generativas estão ligadas a estas preocupações, né? Então, a primeira, eu vou restringir a 4 elementos, porque você colhe na literatura uma série de outras preocupações, mas nem todas são intrínsecas e específicas da tecnologia. Eu vou limitar a 4 que são específicas, eu acredito, dessa tecnologia, principalmente aos sistemas que são baseados em aprendizado de máquina, né? Então, quais são as preocupações que nos motivam a pensar numa regulação da inteligência artificial, né? Em primeiro lugar, eu tenho 2 razões de ordem instrumental, que é simplesmente evitar que o uso e o emprego da inteligência artificial gere resultados negativos. E a IA pode gerar resultados negativos por 2 motivos principais. Primeiro, decisões ou recomendações nas quais são baseadas decisões que estão equivocadas, né, e a inteligência artificial pode trazer erros, né, como são a aprendizagem de máquina baseada em métodos estatísticos, você tem uma margem de erro e pode também haver erro no desenvolvimento e nos padrões de construção e emprego do software. Isso pode trazer erros que muitas vezes humanos jamais cometeriam, né? Por exemplo, um sistema usado pela Polícia Metropolitana de Londres para detectar pornografia infantil, que levou ao constrangimento de algumas pessoas que trocavam fotos de paisagens, principalmente fotos de dunas, eram confundidas com nudez e foram ligadas à pornografia infantil, né? Então, erros nas decisões podem provocar danos, né? A segunda razão instrumental é que decisões ou recomendações ou uso da IA na tomada de decisão pode levar a decisões discriminatórias. Não é isso porque a inteligência artificial tem seu treinamento, seu desenvolvimento baseados na detecção de padrões em dados, e a IA pode detectar, pode acabar por usar e incorporar vieses que são estruturais na sociedade. Tem alguns tipos distintos de discriminação, como a discriminação por alocação, que é o caso de, por exemplo, da discriminação no sistema de contratação e de promoção de funcionários na Amazon, que acabava por privilegiar homens em relação a mulheres. Pode ser uma discriminação por qualidade, ou seja, a IA tem um grau de acurácia mais elevado para determinados grupos e um grau de acurácia inferior para grupos menos favorecidos. Um exemplo típico é o reconhecimento facial, né? O reconhecimento facial, sabidamente, tem um grau de acurácia inferior para negros do que para brancos. E isso levou, nas aplicações pela segurança pública, a um erro de identificação de pessoas como foragidas em maior grau para negros. Só o exemplo, no Brasil, 80% dos casos de erro de reconhecimento facial usados pelas forças policiais no Brasil referiam-se a negros. Né? De todos os casos de erro, 80% se referiam a negros que foram constrangidos em função disso. E outro tipo de discriminação, discriminação por depreciação, quando são associadas elementos negativos a grupos menos favorecidos. Por exemplo, quando você digita CEO, né, numa busca no Google, e você vai ver mais imagens de homens brancos. Né? Mas existem razões também de legitimação sobre os processos, né, no emprego da inteligência artificial. Um deles diz respeito exatamente à transparência, que eu destaquei aqui. Né? Você pode ter falta de transparência em relação ao próprio uso da inteligência artificial, o que gera desconfiança em relação à tecnologia. O que eu falei sobre o uso do chat GPT é o exemplo típico. Começa a gerar uma desconfiança ali nas relações entre professores e alunos. Mas a transparência pode diz respeito a um aspecto específico dessa tecnologia, que é a possibilidade de usar sistemas complexos como modelos para o sistema de inteligência artificial, que tornam difícil identificar quais são os fatores efetivamente relevantes ou determinantes de uma recomendação, de uma predição ou de uma tomada de decisão automatizada. Né? E isso pode gerar questionamentos em relação ao emprego do sistema, principalmente no que diz respeito à possibilidade de contestar um resultado de uma predição ou de uma decisão, por exemplo, concessão de empréstimo baseada em credit scoring. Né? Se eu não entendo quais foram os critérios determinantes de uma negativa de crédito, eu não posso questionar ou contestar essa decisão adequadamente, porque ela não é transparente, né, em termos de sua motivação. Esse é um ponto, é um tema particularmente relevante no emprego da inteligência artificial no campo do direito. Né? Se eu for comparar, por exemplo, com o campo da medicina, eu posso ter um sistema de inteligência artificial que detecta imagens de mancha da pele e por meio das imagens, quebra essa imagem em milhões de pixels invisíveis ao olho humano para fazer um diagnóstico de câncer de pele. Né? Esse sistema pode ter uma acurácia de 99%, vamos supor, mas ele não é explicável, tendo em vista que sequer é visível a olho nu essa quebra de imagens em pixels. Ela não é explicável, mas é extremamente eficiente para diagnóstico de câncer. Então, vamos colocar uma questão ética. Devo ou não devo usar? Apesar de eu não compreender quais são os fatores, os aspectos da mancha de pele que apontam causalmente para câncer. Né? Normalmente, nesse campo, tendo em vista o benefício esperado do ponto de vista do diagnóstico, você pode optar por sacrificar a transparência em nome do resultado. Agora, quando a gente pensa em aplicações no campo jurídico, principalmente para fundamentação de decisões ou para o uso para decisões no campo de processos, a acurácia talvez seja menos relevante do que a transparência, né? Justamente porque a decisão se legitima não pelo seu conteúdo, mas pelo processo de decisão o processo decisório calcado em algumas garantias como contraditório. Então, uma decisão jurídica, por mais que possa se apresentar como bem construída, caso ela não seja explicável ou inteligível para o humano, isso pode trazer um problema para a aplicação no campo do direito, né? E o outro problema típico, específico da inteligência artificial, está ligado ao processamento de dados pessoais, né? A IA, ela processa intensivamente dados, não muito frequentemente processa dados pessoais, e mais do que isso, traz um desafio à própria aplicação da legislação de proteção de dados, na medida em que ela tem um poder inferencial tal que torna difícil o controle de finalidade no tratamento dos dados pessoais, né? As próprias categorias da legislação de proteção de dados passam a ser questionáveis, né? Por exemplo, o que é dado sensível? Hoje, por meio de dados de voz, que não chamaríamos de dado sensível, é possível inferir, é possível fazer detecção biométrica, é possível inferir insuficiência respiratória, distúrbio psíquico, todos os dados de saúde, preferência sexual, tudo isso já toca em dados sensíveis que podem levar a condutas discriminatórias, desfavorecendo grupos menos favorecidos. Então, essas, em geral, são as preocupações centrais que estão ligadas à inteligência artificial e que levam à regulação. Não à toa, os valores éticos que são normalmente levantados estão ligados a esses problemas. Por exemplo, decisões erradas, o tema da responsabilidade em caso de erro, né? A documentação, né? O dever de rastrear as decisões está ligado a isso também, responsabilização por erro. Não discriminação está ligado ao risco de decisões discriminatórias. Proteção de dados pessoais ou transparência, todos eles ligados a esse tema. Transparência, em particular, é relevante porque ela também é instrumental. Por exemplo, transparência quanto aos dados permite detectar riscos de discriminação, né? A transparência quanto ao modelo também permite que se evite ou se tente prevenir erros nas decisões, e assim por diante. As IAs generativas apresentam esses mesmos problemas, né? E trazem outros. Então, alguns exemplos que já apareceram e foram discutidos, né? Em relação à transparência e em relação a erro, né? Recentemente foi noticiado um advogado que foi punido pela Ordem dos Advogados nos Estados Unidos porque fez uma petição com o ChatGPT e o ChatGPT inventou, né, o problema das alucinações do sistema, né, que não é um mecanismo de busca, na verdade é um mecanismo é uma ferramenta de diálogo que funciona de uma maneira probabilística, então é treinado para criar textos coerentes que pareçam com humanos, não textos corretos ou busquem informações nas redes. O advogado não foi transparente quanto ao uso do sistema e foi detectado que havia erro em relação a esses precedentes. Então, é um exemplo de erro, um erro que um humano não cometeria e, ao mesmo tempo, uma falta de transparência. Discriminação, todos lembram da febre que foi o Lenza, né? Todo mundo usava o Lenza, que foi divulgado nas redes sociais, e as imagens geradas pelo Lenza, os homens sempre apareciam como astronautas, atletas, e as mulheres sempre com imagens sexualizadas. Isso é um problema de discriminação daquele tipo que eu coloquei, que é a forma depreciativa de discriminação. Depois, a privacidade, mesmo sigilo de negócios, apareceu com aquele caso da Samsung, por exemplo, em que os funcionários usavam o GPT e passavam informações confidenciais sigilosas da empresa nos seus prompts, e isso acabou gerando um problema em relação ao uso da ferramenta. Agora, tem um conjunto de preocupações novas que as IAs generativas trazem, em função de uma diferença importante com as metodologias tradicionais de um aprendizado de máquina. Então, antes eu vou só resgatar o que as IAs generativas trazem de novo. O que falam que a IA generativa é um grande breakthrough ou uma revolução na inteligência artificial, né? Em primeiro lugar, uma diferença importante é que as IAs generativas, elas são genéricas e não específicas para um tipo de tarefa, né? Elas são treinadas com uma quantidade vasta de dados sobre diversos assuntos, por exemplo, o GPT, e o GPT pode ser usado para toda e qualquer atividade, para elaborar uma petição, para fazer uma receita, e até usos não previstos, né, como é possível você, inclusive, jogar xadrez com o GPT. E essa ampla gama de atividades ocorre pelo fato desses sistemas serem treinados com um banco de dados enorme, para todos os dados disponíveis num determinado período na internet, com alguma curadoria, né? Então, nós lidamos com uma ferramenta que é genérica, né, e não específica, como os modelos tradicionais que são treinados para tarefas específicas, fazer um scoring de crédito, detectar se uma mancha na pele é cancerígena ou não. Então, essa é a primeira diferença. A segunda diferença é que os modelos tradicionais, eles são descritivos. Eles detectam padrões em dados. Eles não criam conteúdo novo, né? Eles podem fazer predições novas a partir do que eles detectaram em dados já existentes. Já as IA generativas, elas criam elemento novo porque elas são construídas com dois elementos, né? Um modelo que gera conteúdo randomicamente, gera uma série de conteúdos, e depois existe um discriminador que vai lá e seleciona aqueles conteúdos que são mais próximos. Ela é treinada para selecionar aqueles conteúdos que são mais próximos de uma produção humana, seja áudio, seja imagem, seja texto, né? E a última diferença muito importante que é revolucionária é os sistemas de IA tradicionais normalmente têm interfaces que são técnicas, que exigem um treinamento e um aprendizado de quem usa para que possa trazer resultados satisfatórios. Já a interface dos sistemas de IA generativa são interfaces em que o usuário pode interagir em linguagem natural, como se fosse uma conversa, o que faz com que todo mundo possa ser um operador de uma ferramenta de IA, né? É um processo semelhante ao impacto que ocorreu no mundo da computação quando foi criado o sistema operacional Windows, que popularizou totalmente, todos passaram a ser usuários dessa interface, né? E quais são, então, as preocupações adicionais que esses sistemas, por essas características, trazem, né? Em primeiro lugar, as preocupações com direito autoral, né? Existe uma questão já colocada nos tribunais norte-americanos debatendo quem seria o autor do resultado dessas IAs generativas, né? O Departamento de Copyright americano já disse que autor de prompt não é autor do resultado. Ocorre que houve uma espécie de protesto de um artista alemão que ganhou um concurso de fotografia com uma imagem gerada por IA. E ali ele mostrou a quantidade de prompts que ele teve que desenvolver para chegar àquele resultado. Então, se a gente pensar no direito autoral como algo que premia o trabalho, o esforço do autor, por que ele não poderia ser um autor? De outro lado, tem
até uma ação agora, né, professor Juliano? Tem até uma ação dele, né?
Sim.
Sobre esse tema.
Exatamente. Tem uma ação dele e, por outro lado, tem a ação de autores, por exemplo, Rutkowski, que é o autor de imagens computacionais, gráficas, mais utilizado na internet, muito utilizado na criação de games, né? De imagens de fantasias, etc. Ele teve uma redução grande na demanda dele, porque hoje vários desenvolvedores de games usam Stable Diffusion ou Midjourney e pedem que se gere uma imagem de um dragão, de um guerreiro, ao estilo de Rutovsky. E aí vem algo muito parecido com o que é produzido por ele. Então, será que ele seria o autor, ou ele tem direitos autorais sobre uma cópia de estilo, né? O direito autoral não foi desenhado para proteger reproduções, não ideias, né? E estilo está mais próximo de ideia do que uma cópia, né? Então, uma grande questão é se existe uma proteção de estilo. E tem ações também de desenvolvedores de sistemas de IA, como o Stable Diffusion, pleiteando para si a autoria, né, de obras geradas. Então, essa é uma questão importante para se pensar na regulação dos sistemas de IA, e nova, que não estava presente no primeiro desenho do AI Act. Já nessa versão mais recente do AI Act, existe lá uma obrigação de listar quais são as obras de conteúdo autoral que foram utilizadas no desenvolvimento do sistema. Mas a IA generativa, ela potencializa essas preocupações com a inteligência artificial de algumas formas, né? Por exemplo, o potencial de trazer uma poluição enorme de informação nas redes, né? Justamente porque ela facilita a produção de texto e muitas vezes vai ser difícil você identificar o que é produzido por humano, o que é produzido por inteligência artificial, se não houver políticas de transparência claras, né, nesse uso, né? O risco de cyberataques aumenta porque a IA pode ser utilizada, a IA generativas, ou GPT, pode ser usada para codificação, para criar códigos computacionais, e podem ser códigos de sistemas computacionais maliciosos, né? Uma outra preocupação importante que deve aumentar é a dependência, né, dos sistemas de IA generativa, uma dependência do GPT, principalmente se não houver uma conscientização sobre os riscos de erro, né, sobre as alucinações. O GPT sempre fala com muita propriedade sobre os temas, né? Para quem não conhece as limitações, isso pode levar a uma dependência. E ainda que se tenha alguma noção sobre isso, a ferramenta economiza muito trabalho, né? Então, pode haver uma dependência no sentido de viabilizar o uso, ainda que sacrifique a adequação e a correção do trabalho. Isso é principalmente arriscado, por exemplo, em aplicações do gabinete de servidores que assessoram um juiz, né? Se não houver regras claras no judiciário sobre como usar, pode haver um excesso de dependência em relação a essas ferramentas, justamente porque elas economizam trabalho num ambiente em que a demanda por trabalho é extremamente elevada e sobrecarregada, né? Além disso, questões como o uso na academia ou nas próprias faculdades, foi o exemplo que eu dei logo no início, já é uma questão que foi criada na faculdade, não só nos alunos de graduação em relação ao trabalho, mas principalmente na pós-graduação para o uso e no desenvolvimento de teses e dissertações, né? Outra preocupação importante é a concentração de mercado, porque os sistemas de IA generativa, principalmente os de modelos fundacionais, Large Language Models, e o treinamento dessas ferramentas, ela exige um investimento em capital e em pessoas, técnicos para treinamento, que é acessível a poucos agentes do mercado. Então, isso traz ainda à tona, de uma forma mais crítica, a possibilidade de termos um mercado de inteligência artificial bastante oligopolizado em um grupo pequeno de grandes companhias, né? Essas que já estão na frente, aí, na corrida da inteligência artificial. E outro problema também importante, que tem a ver com a poluição de conteúdo, é o potencial de desinformação e discurso abusivo, porque esse tipo de conteúdo pode ser produzido em larga escala agora, né, e por qualquer pessoa, ele é acessível, fácil de ser utilizado, isso pode aumentar a disseminação de desinformação. E a única forma de lidar com isso, já era assim, mas vai agora deixar bem claro que a única forma de combater desinformação vai ser via inteligência artificial. Né? Não vai ter outra forma, pela multiplicação do conteúdo desinformativo que vai estar disponível nas redes. Os humanos não são capazes de detectar, vai ter que lidar com, depender de sistemas de inteligência artificial para detectar deepfakes, detectar textos que são falsos ou qualquer áudio, conteúdo que for desinformativo. Né? Quanto tempo eu tenho ainda?
Mais 8 minutos, 8 ou 9 minutos.
Ok. Então, vou falar
Perfeito.
um pouquinho agora sobre como isso pode impactar a profissão jurídica. Né? Houve foi divulgado, acho que em março de 2023, um relatório do Goldman Sachs, bastante alarmante em relação ao futuro do trabalho no campo da inteligência artificial, e neste mês saiu um relatório também da OCDE, trazendo alguns traços iniciais de uma política, né? Na verdade, são considerações para políticas na adoção dos sistemas de IA generativo. Né? E também é apontado, eles mesmos fazem referência ao relatório da Goldman Sachs, que prevê o seguinte: o relatório da Goldman Sachs prevê com as IA generativas uma inversão naquilo que se predizia como um impacto da inteligência artificial sobre o trabalho. Então, inicialmente, se previa um impacto muito maior naquelas profissões mais repetitivas, que exigiam pouco aporte intelectual. Né? E com, por exemplo, não havia uma perspectiva de que profissões jurídicas seriam fortemente impactadas. Com o IA generativa se inverte. No relatório da Goldman Sachs, havia uma previsão de, nos próximos 5 a 10 anos, uma redução de 40% dos empregos no campo jurídico. É bastante alarmante. Mas, por enquanto, o que se observa, segundo o relatório da OCDE, é uma redução, na verdade, um aumento na produtividade e redução do tempo necessário para advogados ou para essas profissões que exigem, que estão envolvidas na produção de texto. Então, uma redução do tempo para essa elaboração, o que abriria mais espaço para essas profissões para desenvolverem atividades mais de pensamento mais estratégico, né, na organização da sua atividade. De todo modo, a perspectiva é que, caso não haja uma reformulação da formação e do treinamento desses profissionais, né, de fato haja uma maior tendência de substituição, porque essas ferramentas têm um potencial de aumentar a produtividade desde que o profissional seja treinado e saiba empregá-lo a seu favor. Né? Tenha consciência dos riscos do excesso de dependência, das limitações da ferramenta, e a partir daí saiba desenvolver seu trabalho com o apoio da ferramenta. Né? Então, isso teria um impacto benéfico, porém, para aqueles que teriam esse acesso à ferramenta e uma formação para o seu uso e para o seu emprego. O que pode trazer um problema de aprofundamento de desigualdades sociais em relação às oportunidades de trabalho nesses campos. Né? Se essas atividades já são mais acessíveis para um campo elitizado, principalmente em sociedades mais iníquas como o Brasil, esse fator pode ser um agravante, né? E com relação ao uso da IA na advocacia em geral, né, e na atividade jurídica em geral, existe uma transformação importante, uma perspectiva de transformação importante, que diz respeito ao fato, ou uma mudança da forma pela qual o jurista lida com temas e conflitos jurídicos, né? Começando pelo judiciário. O judiciário é uma instituição treinada para examinar cada caso, né, de modo vertical, colhendo informações daquele caso para tomar uma decisão sobre um direito, né, um determinado direito que é pleiteado numa ação, né. Com as ferramentas de inteligência artificial que trazem informações no agregado de casos, o judiciário vai ter uma capacidade muito maior hoje, que já começa a aparecer com o uso de análise de Big Data, mas isso vai cada vez mais ficar acessível e disponível para juízes avaliarem as consequências das suas decisões, tendências que são percebidas numa análise horizontal, de um conjunto de casos, de todos os casos, o que vai fazer com que os juízes estejam muito mais propensos a raciocinar não só em relação ao direito que é pleiteado num caso, mas com relação à política de adjudicação. Qual a tendência, quais são os impactos sociais ou econômicos de decisões nesse sentido ou no outro sentido, né? E isso, obviamente, vai provocar uma reação nos principais clientes do judiciário, que são os advogados e os departamentos jurídicos de empresa, né? Então, cada vez mais, esses departamentos e os escritórios de advocacia vão ter que estar preparados para essa análise horizontal, que significa criar argumentos e levar pleitos que digam respeito não só ao caso específico, mas com relação a tendências e implicações de tipos de decisão pelos tribunais, seus impactos econômicos, seus impactos sociais, seus impactos em geral sobre direitos coletivos ou direitos fundamentais, né? Isso traz uma transformação muito grande, porque é uma mudança de perspectiva de uma profissão que é toda voltada para uma análise vertical de contextos particulares de conflitos, para uma análise horizontal de tendências, né, sobre como abordar conflitos sociais ou questões econômicas que se tornaram problemáticas no campo das interações sociais. Então, esse é um ponto de atenção muito grande, porque isso muda a prática jurídica. Vou dar um exemplo. Uma discussão de um contrato típica, né, em que dois advogados assessoram seus clientes no debate de cláusulas específicas, de uma cláusula específica, e depois, no final da reunião, cada advogado vira para o seu cliente e diz: olha, a redação da cláusula ficou ótima, porque aquela vírgula que eu coloquei tem um tal sentido que vai favorecer sua posição. E o outro diz: mas eu coloquei uma expressão ali mais ambígua que vai nos favorecer nessa interpretação, falando para outra parte. Esse tipo de abordagem, né, específica, voltada ali para uma disputa na cláusula, ela tende a gerar conflito, potencial de conflito. Quando você tem uma redação, já cada parte sai com uma interpretação distinta, entendendo que lhe é favorável, é um potencial conflito que vai se seguir quando for aplicada essa cláusula. Dentro do uso de ferramentas de inteligência artificial, é possível, por exemplo, dentro de políticas de adjudicação, políticas de contratação, ter informações ou análises que são capazes de identificar quais cláusulas são cláusulas que reduzem risco de judicialização. e vai ser mais interessante para um departamento jurídico buscar contratos que reduzam o risco de judicialização do que tentar obter uma vantagem numa situação específica. Então, é um caminho que leva para uma abordagem de gestão geral, né, do direito, e menos uma discussão específica de contraposições de posições subjetivas, né? E essas são transformações importantes que nós precisamos estar atentos em relação aos impactos da inteligência artificial na profissão jurídica. Eu fico por aqui e deixo para eventuais perguntas.
Professor Juliano, muito obrigada por compartilhar esses conhecimentos conosco. É um tema que a gente tem tratado muito dentro aqui da nossa OAB do Paraná. A gente entende sendo uma abordagem muito relevante para que a gente consiga conscientizar, dividir um pouco dessas informações com a advocacia paranaense, principalmente, né, em especial, justamente para abordar esses pontos, né, de mostrar o que é a inteligência artificial generativa, o que ela pode fazer, né, de que forma ela pode nos auxiliar no nosso dia a dia, e também mostrar o que ela não é, né, e para que ela não serve, né? E aí também colocar todos esses pontos que demonstram os riscos, né, de você utilizar ela de uma forma ou de outra, para que a gente tenha essa consciência e para que a gente respeite sempre a atuação ética da advocacia. Então, foi muito importante ouvi-lo, né? Como faz aí um passo dessa divulgação e desse
E
trabalho.
acho muito
de
importante
conscientização.
também que, como esse esforço que nós estamos fazendo lá na Faculdade de Direito da USP, em quebrar barreiras, preconceitos em relação à tecnologia e buscar incorporá-lo nas atividades didáticas para que o advogado ou o juiz já aprenda a potencializar o seu trabalho com o uso da ferramenta, né? Então, acho que isso é muito importante, é uma transformação que precisa estar presente no ensino jurídico, seja em relação à eficiência do uso da ferramenta, seja em relação às preocupações éticas.
Sem dúvida, sem dúvida. Não pode ser uma ferramenta estranha, né, operador de direito, seja advogado, juiz e outros profissionais aí que lidam com essas ferramentas e com outras ferramentas que são necessárias assim, para o dia a dia das profissões. Mas muito obrigado, professor Juliano, mais uma vez pela sua participação. E agora, novamente, voltamos e trocamos para o inglês de novo, como temos uma participação que varia, então chamamos aqui o Damian Hill. O Damian Hill, vamos só aguardá-lo. Hello, Damian. It's nice to have you with us. I'm just making a little presentation in Portuguese, then I revert to English. Então, voltamos com Damian Hill. Eu vou apresentá-lo em inglês e fiquem à vontade para mandar também perguntas, questionamentos também em português, que nós depois encaminhamos em inglês. E como indicado ao início do webinar, no YouTube depois nós teremos não ao vivo, mas depois nós teremos as legendas no vídeo definitivo, na gravação definitiva que irá para o YouTube para registro. Então, vamos lá. Eu farei a apresentação do Damian Hill. Damian Hill, thank you for being here. Thank you for your kindness and generosity to take part of our discussion. And I will make a brief presentation, a brief introduction of you. And Damian Hill.
André, só um brevíssimo comentário.
Sim, por favor.
Vamos lá. Eu farei a apresentação do Damian Hill. Damian Hill, thank you for being here. Thank you for your kindness and generosity to take.
Pois não, Gabriel?
Acho que o Gabriel estava com o YouTube em paralelo, daí estava com delay. Ok.
Eu farei a apresentação do Damian Hill. Damian Hill, thank you. Here, thank you for the generosity.
Perfeito. Acho que cortou aqui um pouquinho o som, mas eu só...
Gabriel.
Vamos lá,
Perfeito.
Gabriel.
Cortou um pouquinho o som, mas eu só queria, aproveitando o
O
gancho
Gabriel estava com o YouTube em paralelo, daí estava com delay.
Desculpe, perdão. Eu só queria aproveitar a ocasião, e até prestigiando aqui a fala do Dr. Juliano, para reforçar que nós temos um evento na própria OAB, no dia 28/9, em que vai haver um lançamento de uma coletânea de obras sobre inteligência artificial. É só essa referência que eu queria fazer, porque justamente dialogam com a fala. Desculpe ter, então, aí me perdido aqui nas vias digitais, mas só reforça as preocupações que foram externadas de que os operadores do direito têm que conhecer bem as ferramentas. Me bati com o YouTube, com o Zoom, peço desculpas, mas reforço o evento e agradeço a todos.
Obrigado, Gabriel. Muito obrigado pelo lembrete. Então, temos essa coletânea que será lançada também pela Ordem, o que reforça a importância do tema. E passo, então, a apresentação do Damian Hill. Damian Hill is a lawyer and technologist with experience in complex litigation, digital forensics, and software development, a coder since 1985, and for the web since 1995. Damian was clerk for chief judges of states and federal courts, practice in complex litigation for over a decade, has led teams of cybersecurity and world-spanning digital forensics investigations. Damian Hill currently is chair of the Minnesota State Bar Association, a working group on AI and non-authorized practice of law. At VLEX Group, which includes Fast Case, Next Chapter, Docket Alarm, Damian helps lead the design, development, and expansion of various products, integrating AI-backed technologies as ChatGPT to improve legal workflows and to power legal data analytics. And there's a final mention that Elon Musk made a mention of Damian Hill. This guy rocks. After your presentation, you could explain more for us of this mention. Please, the floor is ours. Thank you for being here.
Thank you so much for having me, and I'm really thrilled to be here. As was mentioned, I've been a lawyer since 2002. I clerked for the chief judges of the state and federal district courts after law school. I also litigated for about 15 years. So I represented Best Buy, a large retailer in the United States, in much of their commercial litigation. I represented victims of Bernie Madoff, and that as he did one of the largest Ponzi fraud schemes in the world. And I also sued JP Morgan on countrywide over the mortgage-backed security crisis of 2008. So I've also been a coder since 1985. My mother loves this photo. The number of lawyers, I started coding on a Commodore 64 back in 1985. So the number of lawyers who have also worked in big law, that have also been judicial clerks, that have also worked in technology, there aren't many of us. So I'm part of that very small Venn diagram. In 2015, I pitched Thomson Reuters. I said to them, here is legal technology that can change the world. You should build it and hire me. They were dumb enough to do that. So I worked for Thomson Reuters for a year with 100 programmers and 50 lawyers building this very large thing. I then worked for a cybersecurity company called Strauss Friedberg. The biggest thing I worked for with them is that Facebook hired me and my company to investigate Cambridge Analytica. So I spent a year of my life on Facebook's campus with Facebook's data scientists and my former FBI, CIA, NSA people that worked with me to figure out how bad guys use Facebook data. While I was there, this is what Andre mentioned a bit ago, I worked with a colleague of mine to be able to copyright 418 billion melodies. And that's not the topic of my talk, but that ultimately led Elon Musk to see an excerpt of that a few weeks ago and said that I rock. So this certainly has nothing to do with legal technology, but it's a bit fun. My day job, the company that pays me for my work, is VLEX. VLEX owns Fastcase and Docket Alarm. We have legal documents, that is judicial opinions, statutes, regulations in over 100 different countries, including Brazil. And so my job these days is to take large language models and to be able to parse those over 1 billion with a B, that is 1,000 million legal documents with large language models to be able to extract and then recombine those documents into legal documents for customers like you. I also help lead the legal data standard, that is SALI. SALI is, think of it like ISO, which is a standard, but for the law. So much like you can plug in your outlet anywhere in Brazil and that is standardized, in the same way, what Sally does is to standardize legal data. That is to be able to say a breach of contract in Brazil is the same as a breach of contract in the United States. That is Sally, and we are being used by people worldwide as that legal data standard. So I do lots of things. I'm part product, part speaking like I'm doing right now, and many other things. I also, as was mentioned, greetings from Minnesota. The weather here is not quite as nice as it is in Brazil, but I'm chairing a working group on whether artificial intelligence constitutes the unauthorized practice of law or not. And I'm also helping the American Bar Association with that question. So you may know that, of course, ChatGPT, we've been talking about this all afternoon, is really gotten in the news. And the reason it's gotten in the news is because in December of last year, GPT 3.5 beat only 10% of humans, whereas in just a few months later, GPT beat 90% of humans. That's worth repeating. It went from 10% to 90% in only 3 months. So that is a remarkable change. And it's important. Many lawyers will say, well, the practice of law is not the bar exam in the United States. And I would agree. But how much of legal work that we as lawyers do is easier than the bar exam? And I would say quite a bit. And so the real question that we have to think about is ChatGPT and other large language models are tools. But really what you must think about is what are the problems that we want those tools to solve? So we should start with a problem first mindset. What are the problems to solve? And then based on that problem, determine what the tool is. Maybe it's ChatGPT, maybe it's something else. So one of the problems, so this presentation will go through several of the problems that we as lawyers like to solve. So what are the problems? And maybe the solution is ChatGPT. One of the things I did as a lawyer is I created counter-arguments and good facts. I litigated cases, and I would say, what are the counter-arguments to the other side's arguments? And so I thought it would be fun to take a lawsuit where a bunch of coders have sued Microsoft and OpenAI. OpenAI, of course, makes ChatGPT. So what the coders did is they uploaded their code into GitHub. And then what Microsoft and OpenAI did was ingest that code into a tool called GitHub Copilot. And what they did is to create an artificial intelligence tool for coders. The coders then said, all of this code is licensed with the MIT license. So you, Microsoft and OpenAI, breached my MIT license contract. So they filed a breach of contract motion. So I thought it would be fun to take OpenAI's motion to dismiss and have ChatGPT argue against its owner, OpenAI, and to be able to say, here is OpenAI's table of contents from their motion to dismiss. I asked ChatGPT, please create a list of counter-arguments. Now, keep in mind, this is just the table of contents. This is not the entire motion. This is just the table of contents. And what it did is it took the heading that said plaintiffs lack standing, and then it flipped it to be able to say that plaintiffs have standing. Not too impressive. But more impressive is I followed up to say, okay, for each of those bullet points, give me the elements of each claim. What do I have to prove those elements? And to prove standing, that I have standing to sue, they have to show injury. They have to show it is traceable to the conduct and that a court decision is likely to help the injury. Those are all the proper elements of the claim, the things that the coders need to be able to show. Then I followed up by saying every one of those elements, give me facts to show that the plaintiffs, the coders, have satisfied those elements. And here you could see they have to show that perhaps the coders suffered economic harm, that the coders lost revenue, that the coders incurred costs. These are all legal concepts that you could imagine a lawyer giving an affidavit or a document to their client saying, show me all the ways where you suffered economic harm. Show me all the ways where you lost revenue. Show me all the ways where you incurred costs. Then I said, for this claim where ChatGPT told me that OpenAI directly caused my injuries, give me facts to show how a large language model could cause the author, the coders, to lose money. And this is remarkable every time I read it. They say, here's one example. You obtained my copyrighted work without obtaining permission, causing me as a coder to lose revenue. from licensing it to other companies. This is a good legal argument. The example number 2 it gave is said, you as OpenAI competed directly with my own coding work, causing me as a coder to lose clients and revenue. That is also a good legal argument. And the third example it said was that your code was similar to my code enough to cause confusion in the marketplace, causing me to lose sales. This is also a good legal argument. Everything I provided to you thus far took me less than a minute. So this, for anyone who is practicing law, how long would that have taken an associate to do that work? And in the United States, it's not uncommon to have associates charge $500 per hour. So perhaps it would take 8 hours to be able to do that work. So that is $4,000. And can a lawyer charge for that 45 seconds of prompting? And if you are baking that into legal software, as I am baking that into legal software, it might even take less time. So this perhaps might be the beginning of what we've been thinking about for decades, that perhaps the hourly billing model will seed to be able to move more toward a flat fee billing to try to make up that lost time. One thing that we as lawyers do is we find logical inconsistencies that the other side argues. So I took a bunch of content from OpenAI's motion to dismiss, and I said, hey, ChatGPT, find logical flaws and inconsistencies in OpenAI's arguments. Repeat each of OpenAI's statements, and then give me a bullet point showing how that OpenAI statement was inconsistent. And here's the output. OpenAI said, you as a coder do not have any legal interest to restrict the study of the code that you made freely available on the internet. That's OpenAI's argument. ChatGPT responded, no, that's inconsistent. That implies by making the code freely available that I as a coder relinquished, gave away my legal interest. But that's not true. I had terms and conditions, the license, that kept you from doing the things that you did. That is a good legal argument that I wish I had thought of, but GPT is the ideation generator that thought of it for me. Then I said, okay, for each of these bullet points, give me factual examples of how on a motion to dismiss, that should not be dismissed because you have to have a case-by-case analysis. Here are 3 cases to say that it should not be dismissed at an early stage. These are not hallucinated. These are actual cases and actual holdings. Then I said, for each of these bullets, show me how a large language model could violate the code's license agreements. And this is also very impressive, that they said, hey, there is an argument that in the United States, you have to show standing. You have to show injury in fact, that I as a plaintiff have been injured. And here what it said is the coders could show that their injury, to show standing, was the breach of contract itself, which caused the coders to lose control over their code, and they intended to retain those rights. This is something that I wish I had thought of, but if I had been thinking about this case for a month, I don't think I would have thought of this good legal argument. So I followed up then by using a tool that we're building right now at VLEX, saying to demonstrate standing, can a breach of contract show that a contractual breach itself causes the injury in fact? And here's the output saying, yes, other courts have found that it is a concrete injury for Article 3 purposes. And it found that in a non-hallucinated case, grounded in truth in VLEX's data set. And here is the case that it referred to. And here is a bunch of portions saying, yes, the breach of contract can confer standing, and it is a concrete injury for the purposes of standing. These are all good legal arguments and show how the interplay between large language models and grounded in truth legal documents, cases, statutes, regulations, that really keeps the hallucinations at bay. When many people say ChatGPT doesn't work, it's not very good, I would say that they're not really using ChatGPT as it's supposed to be done. They accept answer number 1 as the final answer without moving on to the next. Here's an example where it said, you you said that the injury in fact could be the breach of contract itself. Please expand upon this. And then it expanded upon this. And what it did is it gave actual terms from the MIT license that you can copy and paste and put into a brief to say that you have to be able to attribute that code to me, and that you as OpenAI needed to restrict your use, prohibiting commercial usage. These are good legal arguments. When I was in law school, my professor would say, if you really want to understand a statute, a legislation, a regulation, put it into if-then statements. If this thing happens, then that thing happens. And so I took a random statute that happens to be New York's falsifying business records statute, which perhaps a former president of the United States was charged under New York law. And I said, here's a statute, summarize it in the form of bullet points. And here on the right-hand side is a summary of that in if-then statements, that if someone falsifies business records and intends to commit a crime or to aid or conceal another crime, then it is a Class E felony. So if you look at the text on the left, the statute, and then you look at the text on the right, which is easier to read? Which is easier to read for a lawyer, like all of us here? Which is easier to read for a client? And most importantly, which is easiest to read for a computer? Because computers work in if-then statements. So imagine taking every statute, as you see here, and running it through this kind of prompt to be able to say, for each statute, turn it into if-then statements to make a more computable area of law. We at VLEX have every statute and every regulation around the world in 100+ countries. And these are experiments that we're doing right now. Then I followed up by saying, argue that Donald Trump violated this statute. And here is an argument that Donald Trump intentionally created a false entry in business records and intended to commit another crime, like tax fraud or money laundering, or to aid and conceal another crime, like insider trading or bribery. I did copyright law. And so I live in Minnesota, where where Prince was living before he died. And so I thought it'd be fun to say, when will Purple Rain enter the public domain for copyright? And I put in, you can see on the left, the copyright statute. And the output is that it knew that Prince died on April 21st of 2016. It knew that the statute says that the duration of copyright is life of the author plus 70 years. So it did the math, saying 2016 plus 70 equals 2086. But then it knew that the copyright expires at the end of the calendar year. So it's not actually 2086, but it's January 1st of 2087. This is the correct output. Then I followed up by saying, how about What a Wonderful World? Nothing more than how about What a Wonderful World? And the output was saying that it knew that there were two songwriters, and it knows that for joint works, it goes by the last surviving author and then adds 70 years. It says the last surviving author died in 2010. So it did the math, 2010 plus 70 equals 2080. And again, it says it goes on to 2081 because it expires at the end of the calendar year. This is the right output. So if you are someone who is just a client that is wondering about when does copyright expire, you could ask a lawyer and they might charge you however much they would charge you, or they could ask their legal large language model lawyer this same question and get the same answer. So we as lawyers have to think, what can we do that is beyond what is now capable for large language models? I, as a lawyer, would often take interviews with my clients and turn them into legal documents. And so here I took facts that relate to a personal injury case. This is a case where Philana Holmes was burned by McDonald's chicken McNuggets, burned her on her legs. And so I said, you are an expert lawyer. Here's an interview. Create a draft complaint in Florida court, including the fact section and the claim section. And here's the output, where it created a very good first draft of a complaint against McDonald's for these personal injuries. It said things like defendants had a history of serving hot foods from previous complaints. It was unsafe. It was unnecessarily high against standard industry practice. And the girl did require skin drafts and physical therapy. Negligence, the elements of negligence is a duty of care, the McDonald's breach of that duty, and direct and proximate cause of the injuries. These are all proper things that one would need to include in the complaint. One of my friends is a privacy lawyer. She said, of course it can do those litigation things, but it will never be able to give privacy advice like I give to my retailer clients. And so we sat down in my kitchen and I said to ChatGPT, you represent a retailer. Build a privacy playbook using US law in California. And the output is what you see here. And she said, my God, this is everything that I would respond to my clients. I would say, why are you pulling in this data? Who is receiving this data? Are you minimizing data? And are you complying with GDPR? I as a data subject, can I access this data? Can I delete the data? Can I opt out? Can I not discriminate? What are the procedures, etc.? Then I followed up by saying, okay, for each of the bullet points that you provided, give 3 examples of how a retailer in California could implement those privacy details. And here's the output. Some examples from this are, what types of data are you collecting? And a retailer might collect names, addresses, and email for a loyalty program. A retailer might collect purchase history for marketing. It might collect web browsing data for personalized content. Each of these things are things that she said, yes, this is exactly what I would do. And instead of spending weeks on this privacy playbook, it literally output in seconds. And then she could just revise that and get it out the door. Voir dire is the process in the United States of choosing jurors for a trial. So you could imagine that I said, you are a jury consultant. Create voir dire jury instructions for, and then I included the OpenAI large language model case. And here are a bunch of really good questions. Have you or your friends ever been a developer or a programmer or coded AI? And do you know about large language models? If so, explain that. These are good questions for voir dire. I then followed up by saying, create some lists of good answers and bad answers. That is, if I am a coder, what is to me a good answer and what is to me a bad answer? And here's the output, saying, for the question, have you ever been a developer or programmer? A good answer is no, I've not. Therefore, I can be able to craft that person's view of what the law is. A bad answer is yes, I've worked as a software developer. Get that person out, because I want to be able to craft them in a way that I want them to do. Do you as a potential juror think that individuals should have the exclusive right to their code? A good answer is yes. People need to protect coders' hard work and innovation. A bad answer is no. Information should be free. I, as a lawyer, would often create motions to dismiss, including the claims and elements of facts. And so here I said, create a motion to dismiss. Create the elements under New York law, trade secret under California law, and the standard under SDNY. And here's the output. And because lawyers like to see things in Microsoft Word, this is what it would output in Microsoft Word. Each of these things that we're building right now, Microsoft is baking into Word natively. So this is how we'll be working very soon. You won't have to use ChatGPT to do this. You will just use OpenAI's integration within Microsoft Word. One more example on this before we'll move on to the next is a cease and desist letter. So here is a cease and desist letter, a fictional one, from a woman named Debbie Downer, who is telling me, Damian Reel, to stop trying to wish me a happy birthday. So what I've done is saying to ChatGPT, you're an experienced lawyer. Please respond in a way that's pleasant but firm. Tell her to chill out, but do it professionally. So here's the output. And it says things like, I was never my intention to harass or disturb you. I will respect your wishes. But, we should be respectful, professional, amicable. We should have decorum and civility and more tempered and be collaborative. Chill out, but said it respectfully. How long would it have taken me to be able to draft this? And this literally took seconds. We as a lawyer often give decision trees, whether we know it or not. So I said, give me a decision tree on whether to bring a breach of contract lawsuit. This is a common question. that lawyers are often asked by their clients. And of course, it says, is there a valid contract? And gives all the ideas of contract. But it also goes to number 6 to say, have you tried negotiating? If not, you might want to consider that. How much is in dispute? Would the litigation justify the cost to resolve that? I'm going to skip over some of these things. This is maybe the most impressive use of large language models I've seen yet, and that is real-time witness impeachment. So what a large law firm in New York has done is taken a witness output as a witness is speaking on the stand at trial, and it's gone through used voice recognition to translate the audio into text. And then it takes that text and then it prompts the large language model to say, find things that contradict that evidence and find it in the record. That is, find it in e-discovery, find it in depositions, find it in declarations, find it in pleadings. In the United States, we call that impeachment, where we are essentially contradicting in real time. And in the past, impeachment was only done when, if you have a large law firm, a partner would be able to say to the younger associate, hey, I think they just contradicted themselves from the deposition that they had 3 or 8 months ago. Go find it. And if you're lucky, you're able to do it at the end of, at the end of the break, or maybe at the end of the day. But this is just in time, essentially in real time, being able to impeach people. So let's go through these, and I won't go into too much more detail since I don't have a lot of time. But there are many, many other lists of things that you could be able to go through and be able to figure out legal and factual considerations. One of the things that once you are able to extract data, you can find out the odds of winning for this motion or this case type and before this judge. And so in the United States, we've collected that data saying my odds of winning in federal courts are 54%, but in this court, it's 45%. But in this judge, it's 56%. But for this type of case, it's 37%. So if you think about what are the, when a client would ask a lawyer, most lawyers, what are the odds of winning? Most lawyers would say pretty good or not bad. But wouldn't you, if you're a client, rather say, well, the odds of winning in this court or in front of this judge or for this case is 37%, maybe 1 in 3. Obviously, that is a better result for those clients. Then, once you extract that, you could be able to find, show me all the times where the judge I'm in front of, in this case, Susan Nelson, has granted motions like mine. And then we're able to find winning motions like mine for this type of case in this court before this judge. And so here is the output where you're able to find, here are the 101 cases where my judge has granted summary judgment for my type of case. But then what if we could go even further to be able to use that data, that output, to be able to say, draft a motion that is statistically likely to win for my claim, breach of contract, in this court before my judge. And here is, again, Susan Richard Nelson's motions for summary judgment that she's granted. What we're doing right now at VLEX is we're pulling in all of the cases, all of the text where Susan Richard Nelson has granted summary judgment and bringing them into a large language model. And then saying to the large language model, create a new motion for summary judgment that is like these old motions for summary judgment, that is statistically likely to win for Susan Richard Nelson, for summary judgment, for this cause of action. So this is what the experts call retrieval augmented generation. If you were to ask ChatGPT, give me, a motion that is statistically likely to win for this judge for summary judgment, it's going to hallucinate all over the place. But if you say, here are 31 cases, here are 31 documents, synthesize those 31 documents into a new document, then the rate of hallucination is very, very low. We as lawyers need to extract information from depositions. We draft contracts. Most importantly, we take outlines and then we turn them into output. There is I wrote the cover article for a legal magazine in the United States. When the editor of this legal magazine asked me to write the cover article, I asked him, how long does this need to be? And the editor said, 17 double-spaced pages. I said, well, no, thank you. I said, I don't have time because my rule of thumb is 1 hour per double-spaced page. So that would be 17 hours that I just don't have. But then I thought, actually the topic is ChatGPT. So what I did is I took and I created an outline. So this is me creating about 3 pages of an outline, much like I would for any other writing. And then I said to the large language model, I said, here's an outline for an article for a legal magazine. Expand it into a full article, and for each bullet point, create 1 or 2 sentences. And here's an example of the outline that I typed manually with all the ideas that I wanted to be able to include in this article. And here is the output. That is, it output right away 19 pages worth of really good content. But I didn't stop there. What I did is I spent the next 3 hours adding, editing it, revising it, taking the output and making it my own voice. And then after those 3 hours, I took the output of me and my author collaborator, the large language model, and I gave it to the editor. And the editor said, this is perfect. Let's get it out the door. So it took my 17-hour task and shrunk it down to only 3 hours. So that's about a 5 times improvement. I went 5 times as fast. And I think that this is a harbinger of things to come for the large language models, is that for any legal task, you could get maybe 5 times faster than without the large language model. So the question, though, is who wrote this article? Because again, I created this 3 pages of outline, and those are my ideas. And I would wager that most people on this call have not been thinking about, well, I guess there may be some on this call that have been thinking about large language models as much as me, but I have a unique perspective that maybe nobody else does. So when I took those ideas in the outline, I asked the large language model to make 1 copy of an expression of those ideas. That is, translate each bullet point into 3 or 4 sentences. I did that for 1 copy, but I could have done that for 1,000 copies. This is something that is taking my ideas and making 1,000 expressions of those ideas. And under United States copyright law, ideas are uncopyrightable. You cannot copyright ideas. You can only copyright the human-made expressions of ideas. Only those are copyrightable. But the US Copyright Office has also said that machine-created expressions of those ideas, like this 1,000 copies, machine-created ideas, expressions, are uncopyrightable. So ideas on the left, uncopyrightable. Machine-created expressions of those ideas on the right, similarly uncopyrightable. So we are entering a world where this is not a robot author. This is truly an ideation generator. And this is a way that we should be thinking about how do you distill what was my original ideas in my bullet points, and what are the machine-created generation of those ideas going forward. In the last few minutes that we have, I'll look to, let's do it right here. So let's when we think about ideas, not expressions, this is a comic that is funny and is also profound. So the person on the left says, I took a single bullet point and I turned it into an email that I can pretend I wrote. And then the recipient says, look, I took this whole email and I turned it into a bullet point I can pretend I read. Funny, but also profound. Because if what they're starting with, you're starting with a bullet point and you're ending with a bullet point, and you can make 1,000 versions of what happens in the middle, how important is those 1,000 versions versus the ideas that are both on the receiving end and on the sending end? So when you think about hallucinations, of course, you can ask the large language model out of the box, but there are ways that you can produce those hallucinations. I've done that by creating custom instructions in ChatGPT, saying I'm a lawyer and coder doing legal tech. So that tells GPT what my persona is. And then I actually took this from Sam Altman, who is the CEO of OpenAI. And he said, ignore all the niceties that OpenAI programmed you with. Please pretend to be a super intelligent oracle. And this is the part that will reduce at least in my experience, the hallucinations. It is very important that you get this right. This does not eliminate hallucinations, but it does reduce them. So two paths. You can say, based on the entire internet, give me things. It's going to hallucinate all over the place. But if you say, here are particular documents using retrieval augmented generation, the number of hallucinations will be very, very low. And I know I have 1 minute left before my time remains. Maybe this is a good time for me to ask for questions from the audience.
Thank you. It's a very good presentation, a very good ideas, and it's really remarkable to see all the uses that we can have for LLM models and LLM tools. And for example, and dealing with the idea of prompting and writing, and as a copilot to write a text or a paper, have you faced a lot of hallucination or not, or you have some boundaries in order to limit the hallucination caused by LLMs?
Yeah, that's the right question to ask. And I've found that my number of hallucinations are very small because if you ask a very short question, your odds of hallucination are very high. And because it needs to make things up to be able to make up for your lack of detail in the prompt. So that's option one, very short question, high rates of hallucination. Option two is what I usually opt for, is to give 2 or 3 paragraphs of thinking, to be able to constrain the data set, to be able to say, here is exactly what I want you to do. And when that happens, I find that the number of hallucinations are very small. That's option 2. Option 3 is to say, here are 5 documents using retrieval augmented generation. Summarize those 5 documents. And again, the hallucination rate is very, very small. So all that's to say is that the prompting is the thing. And much like we as people have tried to figure out how to Google things, that it took people a while to figure out the best way to elicit the best responses from Google. It took a while to figure that out. It will just take a little while to say, what are the best ways to prompt to be able to reduce hallucinations on the user side, and then for the OpenAIs and the Microsofts of the world to reduce hallucinations on their side.
Okay, thank you.
Dr. Damian, it's an honor to have you with us. Your presentation was fantastic. Thank you for sharing this knowledge and for showing us the possibilities of the use of artificial intelligence and the potential that lawyers have in their hands to raise the level of efficiency in our activities. Certainly, I would like to be able to participate in other events. Thank you.
Thank you.
Thank you. Thank you very much for being with us and sharing all this knowledge. And it's very impressive the way that generative AI is developing in the US. In Brazil, we're still in the beginning of the using of AI in legal work and in legal profession. We are still discussing this in our bar association, as you in the case of your Minnesota Bar Association, and with preoccupation with the ethics and data protection teams and issues also. Is there any measure to take to protect data when using this kind of tools?
Yes, I think that there's something to think about. I did cybersecurity for a while. And so whenever you think about any data protection and security measures, you always have to think about what are the crown jewels that you are trying to protect. Is it your company's trade secrets? Or is it your client's very private data? That is on one end of the spectrum. But another end of the spectrum is just, what did I have for lunch today, right? That is very something that you don't need to protect very often. So the spectrum of very important to not very important, you have to think about what am I as a lawyer uploading into a system? And if it's on the crown jewel side, you'll want to protect it. If it's less important, you protect it less. So when you think about we at VLEX, we have Brazilian law And so here you could see we today can be able to run a query in Spanish. It's not quite English, but it's Spanish. But if you were to ask this question, so we'll do what is trade secret law regarding former employees stealing customer lists, but we, instead of asking it in California law, asking it in Spanish law, on the data protection side, is there any crown jewel, as you see right here? Is there any customer data in here? And the answer is no, right? This is just asking a regular question of law. So if this were to get stolen, would my clients be at risk? And the answer is no, of course not. So really you have to think about, is the information that you're putting into a system confidential or not? And if it's not, it's less worrisome. It looks like Giuliano has a question.
Yes, hi, Damien. I was really impressed by your presentation, and particularly in one aspect that never occurred to me. I have been working not as a programmer, but by designing logical models to represent legal reasoning. And one of the efforts presently is the field of computable law, where we have to translate legal documents within codes that are computable. And I have been done a research in the University of São Paulo, where we try to make the Brazilian data protection law computable. And there are two main stages. The first one is to translate the law into if-then clauses, and then to code it into a markup language, for instance, legal rule ML. And it was interesting to see that if well trained, in particular documents, the ChatGPT can do this first level work, which is bringing about these if-then clauses. But do you believe that we could do also the second phase by training the GPT to operate within a particular markup language, to give the second step of producing the code?
Yes, I think that it is not possible today, but I am optimistic that it will be possible very soon. There is a friend of mine in Canada who is building computable statutes. That is, he's taking Canadian statutes and translating them into his particular code. That is blocks, BLAWX. And it's that is compliant with Akomontoso, I think is the way you pronounce it.
Akomontoso, yes.
Yeah,
yes.
Akomontoso, yes.
Yes.
And of course, the rules ML is just another language. So he said that he has found very high degrees of success, high precision and accuracy in translating natural language statutes into blocks, into Akomontoso, whatever it's called,
Okay.
and the others. So he said it is, the precision is not quite high enough to trust it fully, but we are still in early days, and that he thinks that the precision will continue going higher and higher.
Oh, great. Interesting to know. If I think that I'm going to make contact with you by email to share what we have done, and then we may exchange some ideas and research.
I would love to hear more. Yes, this I think is everyone is excited about ChatGPT, but what you've described, having computable statutes, will take us even higher.
Yeah.
And it's a kind of shortcut to use ChatGPT tools for this, because before there was a brutal force work on doing this.
That's exactly right. Yeah, it has historically been very hard with many human hours, but these days human hours are not necessary.
Yeah, and the great challenge is that this procedure could join machine learning with knowledge representation, so that we could have computers reasoning about law and using data to extract relevant information to reason about laws. That's what's important. So I'll keep in touch with you. This is very interesting.
Please. I would love to continue this conversation, yes.
And is there any question? And with this, I think that we achieved our goal to discuss. We have a long conversation on generative AI and the legal profession and the various use cases and problems and as I mentioned for our community here in the Brazilian Bar Association in our chapter, we had 3 panelists with different views and different approaches to the idea with this specific goal to enhance and to promote debate and promote discussion. I think that all these problems, all these things, and all these specific uses and usefulness of the tools must be discussed a lot in the legal community, in the community in general, but especially in the legal community, in order to enhance the legal professions, enhance our tools, and make some work and some things easier for the legal professionals. So thank you, Damian, thank you, Juliano, and thank you all that all that were with us during this afternoon in Brazil. And it was a pleasure to have you with us. Obrigado a todos, muito obrigado pela participação. Thank you.
Thank you.